on page 99 of the Barbri outline for real property, I'm going to discuss some exceptions to the statute of frauds. There's the doctrine of part performance. A court may give specific performance of a contract, though not damages, despite the absence of a writing if additional facts are present. Theories to support the doctrine is the evidentiary theory and the hardship or estoppel theory. Courts state under the evidentiary theory that if acts done by a party can be explained only by reference to an agreement, these acts unequivocally establish the existence of an oral contract. And B, hardship or estoppel theory. If acts done by a party in reliance on the contract would result in hardship to such an extent that it would be fraud on the party were the contract not specifically enforced, the other party would be estopped from asserting the statutes of frauds as a defense. Now, the second exception is the second part of the doctrine of part performance is acts of part performance. So in most states, two of the following are required, which is possession of the land by the purchaser, Ruminant 2, making of substantial improvements, and or Ruminant 3, payment of all or part of the purchase price by the purchaser. Some state courts will go beyond this list and will accept as part performance other types of detrimental reliance by the purchaser, such as performance of services or sale of other lands. The third part of the doctrine of part performance questions: can the seller obtain specific performance based on buyer's acts? And there's the evidentiary theory again and the hardship or estoppel theory. Under the evidentiary theory, it is immaterial who performed the acts constituting the part performance because they refer unequivocally to a contract. The seller may obtain specific performance based on the buyer's acts. Under the hardship or estoppel theory, however, the plaintiff must be the one whose action would result in hardship if the statute of frauds were invoked. Consequently, the seller normally cannot rely on the buyer's acts. Even so, make sure that you ascertain whether the seller has done anything that would cause him a hardship if the statute of frauds were successfully asserted by the buyer. I feel like we had some cases that established that knowledge was a critical element, at least in the hardship or estoppel theory. But I'll leave it at that, and maybe we'll get into it later. Now going into the second exception, which is the doctrine of equitable conversion. Under the doctrine of equitable conversion, once a contract is signed and each party is entitled to specific performance, equity regards the purchaser as the owner of the real property. This actually is not an exception of the statute of frauds. We just went over the two exceptions and what they're like. This is a different doctrine, which protects from the risk of loss. So, the seller's interest, which consists of the right to the proceeds of sale, is considered to be personal property. The bare legal title that remains in the seller is considered to be held in trust for the purchaser as security for the debt owed the seller. But note that possession follows the legal title, so even though the buyer is regarded as owning the property, the seller is entitled to possession until the closing. So in case I didn't finish that definition, under the doctrine of equitable conversion, once a contract is signed and each party is entitled to specific performance, equity regards the purchaser as the owner of the real property. Risk of loss. A. If the property is destroyed without fault of either party before the date set for closing, the majority rule is that because the buyer is deemed the owner of the property, the risk of loss is on the buyer. Thus, the buyer must pay the contract price despite a loss due to fire or other casualty, unless the contract provides otherwise. Some states, however, have adopted a Uniform Vendor and Purchaser Risk Act, which places a risk on the seller unless the buyer has either legal title or possession of the property at the time of the loss. Casualty insurance. Suppose the buyer has the risk of loss, as is true under the majority view, but the seller has fire or casualty insurance that covers the loss. In the event of loss, allowing the seller to recover the full purchase price on the contract and to collect the insurance proceeds would be unjust enrichment. Hence, the courts require the seller to give the buyer credit against the purchase price in the amount of the insurance proceeds. Letter B, under the doctrine of equitable conversion, is the passage of title on death. The doctrine of equitable conversion also affects the passage of title when the party to the contract of sale dies before the contract has been completed. In general, it holds that the deceased seller's interest passes as personal property and a deceased buyer's interest is as real property. Death of seller. If the seller dies, the bare legal title passes to the takers of his real property, but they must give up the title to the buyer when the contract closes. When the purchase price is paid, the money passes as personal property as those who take the seller's personal property. Note that if the property is specifically devised, the specific devisee may take the proceeds of the sale. Death of buyer. If the buyer dies, the taker of his real property can demand a conveyance of the land at closing of the contract. Moreover, under the traditional common law rule, they are entitled to exoneration out of the personal property estate. Thus, the takers of his real property will have to pay the purchase price out of their share of the buyer's estate. However, a majority of states have enacted statutes abolishing the doctrine of exoneration, and in those states, the takers of the real property will take it subject to the vendor's lien for the purchase price. In these states, as a practical matter, the takers of the real property will have to pay the price unless the testator specifically provided to the contrary. Marketable title. There is an implied covenant in every land sale contract that at closing the seller will provide a buyer with a title that is marketable. Marketability defined. Title reasonably free from doubt. Marketable title is title reasonably free from doubt. For example, title that a reasonably prudent buyer would be willing to accept. It need not be a perfect title, but the title must be free from questions that might present an unreasonable risk of litigation. Generally, this means an unencumbered, fee simple, with good record title. 1. Defects in record chain of title. Title may be unmarketable because of a defect in the chain of title. Examples include a significant variation in the description of the land from one deed to the next, a deed in the chain that was defectively executed and thus fails to meet the requirements of recordation, and evidence that a price grantor lacked capacity to convey the property. Many courts hold that an ancient lien or mortgage on the record will not render title unmarketable if the seller has proof of its satisfaction or the statute of limitations on the claim would have run under any possible circumstance, including tolling for disabilities. There is, under defects in record chain of title, if that wasn't enough, there is adverse possession, future interest held by unborn or unascertained parties. So, for adverse possession, historically, a title acquired by adverse possession was not considered marketable because the purchaser might be later forced to defend in court the facts that gave rise to the adverse possession against the record owner. On the bar exam, title acquired by adverse possession is unmarketable, despite the fact that most modern cases are contra. Most of the modern cases hold adverse possession titles to be marketable if the possession has been for a very lengthy period, or Romanet 2, the risk that the record owner will sue appears to be very remote, and Romanet 3, the probability of the record owner's success in such a suit appears to be minimal. Because the bar examiners have yet to recognize this line of cases, the modern view should be considered only as a fallback position on the bar exam. Letter B, future interest held by unborn or unascertained parties. Even though most states consider all types of future interests to be transferable, it is often impossible for the owners of the present and future interests acting together to transfer marketable, fee simple, absolute title. This is because the future interests are often held by persons who are unborn or unascertainable. So, for example, to A for life, and upon A's death to A's eldest surviving daughter. Assume that at the time of the conveyance A has one daughter. B, state the title. A has a life estate and B has a contingent remainder. A and B together can transfer the land to a purchaser, such as C, but the title is not marketable. It may turn out that upon A's death, B will have predeceased A, and some other daughter, perhaps not even yet born when A and B transfer to C, will be the A's eldest surviving daughter. Because the daughter did not join in the conveyance to C, she is not bound by it, and she owns the land. On the other hand, if B does turn out to be A's eldest surviving daughter, which cannot be determined until A's death, then C's title will become marketable fee simple at that time. While most courts will appoint a guardian ad litem to represent unborn or unascertained persons in litigation, the majority will not appoint such a guardian for purposes of conveying the land. So these are chain of title problems that we didn't discuss in class. So good to include adverse possession here as well as future interests. Encumbrances. Generally, mortgages, liens, easements, and covenants render title unmarketable unless the buyer waives them. So, mortgages and liens. A seller has the right to satisfy a mortgage or lien at the closing with the proceeds from the sale. Therefore, as long as the purchase price is sufficient, and this is accomplished simultaneously with the transfer of title, usually through the use of escrows, the buyer cannot claim that the title is unmarketable. The closing will result in a marketable title. Easements. And the mortgage doesn't have to be satisfied for the transfer of title, which, if the seller stops paying, which is likely, then that can be enforceable on the property securing the instrument. Easements. An easement that reduces the value of property. Example, an easement of way for the benefit of a neighbor renders title unmarketable. The majority of courts, however, have held that a beneficial easement, for example, utility easement or to service a property, or one that was visible or known to the buyer, does not constitute an encumbrance. Some courts go so far as to hold that a buyer is deemed to have agreed to take subject to any easement that was notorious or known to the buyer when she entered the contract. Covenants. C. Restrictive covenants render title unmarketable. Encroachments. A significant encroachment constitutes a title defect regardless of whether an adjacent landowner is encroaching on the seller's land or vice versa. However, the encroachment will not render title unmarketable if, ruminant 1, it is very slight, only a few inches, and does not inconvenience the owner on whose land it encroaches. Ruminant 2, the owner encroached upon has indicated that he will not sue on it. Or ruminant 3, it has existed for so long, many decades, that it has become legal by adverse possession, provided that the state recognizes adverse possession titles as being marketable. And third, zoning restrictions. And fourth, waiver. Third, generally, zoning restrictions do not affect the marketability of title. They are not considered encumbrances. An existing violation of a zoning ordinance, however, does render title unmarketable. And waiver, any of the above-mentioned title defects may be waived in the contract of sale. Quitclaim deed, no effect. This is letter B under what? Marketable title. The fact that a contract calls for a quitclaim deed which does not contain any covenants for title does not affect the implied covenant to provide marketable title, unless so provided in the contract. Time of marketability. This is letter C under marketable title. If, as is usual, the seller has agreed to furnish title at date of closing, the buyer cannot rescind prior to that date on grounds that the seller's title is not marketable. One, installment land contract. So that wouldn't give the seller the opportunity to, like, say, for instance, pay off the mortgage, which may be done with the proceeds from the sale. So, anyhow, installment land contract is number 1 under the time of marketability. Similarly, where an installment land contract is used, the seller's obligation is to furnish marketable title when delivery is to occur. For example, when the buyer has made his final payment. Therefore, a buyer cannot withhold payments or seek other remedies, for example, rescission, on grounds that the seller's title is unmarketable prior to the date of the promised delivery. The buyer might get rescissionary relief before the date of delivery by showing that the seller cannot possibly cure the defects in time or Under compelling circumstances, the court might require the seller to quiet title during the contract period. D. Remedy of title not marketable. If the buyer determines that the seller's title is unmarketable, he must notify the seller and give a reasonable time to cure the defects, even if this requires extension of the closing date. The notice must specify the nature of the defects. If the seller fails to cure the defects, the buyer may pursue several remedies, which include rescission damages, specific performance under 1, merger under 2. And surprisingly, that is it. So 1, rescission damages and specific performance. In the absence of a contractual stipulation to the contrary, if title is not marketable, a buyer can rescind, sue for damages for breach, get specific performance with an abatement of the purchase price, or, in some jurisdictions, require the seller to quiet title. The seller cannot sue successfully for damages or specific performance. 2. Merger. If the buyer permits the closing to occur, the contract is said to merge with the deed, i.e. it disappears, and in the absence of fraud, the seller is no longer liable on the implied covenant of marketable title. However, the buyer may have an action for violation of promises made in deed, if any. Note, the merger rule does not apply in most non-title matters, such as covenants regarding the physical condition of the property. And citing Campbell v. Rawls from Florida, 1980, didn't read that case. Number 4, time of performance. Number 5, tender performance. Number 6, remedies for breach of the sales contract. Number 7, seller's liability for defects on property. Number 8, real estate brokers. And number 9, title insurance. So that consists of 4 pages, and I am at 16 minutes. Let's go for it. Time of performance, presumption. Time not of the essence. In general, the courts assume that time is not of the essence in real estate contracts. This means that the closing date stated in the contract is not absolutely binding in equity, and that a party, even though late in tendering her own performance, can still enforce the contract if she tenders within a reasonable time after the date. A month or 2 is typically considered a reasonable time. B. When presumption is overcome, time will be considered of the essence if the contract so states, or 2, the circumstances indicate it was the party's intention. For example, if land is rapidly fluctuating in value, or a party must move from out of town and has no other place to go. Or 3, one party gives the other notice that she desires to make time of the essence and does so within a reasonable time prior to the date designated for closing. C. Effect of time on the essence construction. Time of the essence construction. If time is of the essence, a party who fails to tender performance on the date set for closing is in total breach and loses her right to enforce the contract. And D. Liability when time not of the essence. Even if time is not of the essence, a party who is late in tendering performance is liable for damages for the incidental losses she has caused, such as additional mortgage interest, taxes, etc. 5. Tender of performance. In general, the buyer's obligation to pay the purchase price and the seller's obligation to convey the title are deemed to be concurrent conditions. This means that neither party is in breach of the contract until the other party tenders her performance, even if the date designated for the closing has passed. A. When parties tender excused. B. Neither party tenders performance. C. Buyer finds seller's title unmarketable. So for A, when the party's tender is excused, a party's tender is unnecessary and is excused if the party has repudiated the contract, or if it is impossible for the other party to perform. For example, if the seller does not have marketable title and cannot get it. And B. Neither party tenders performance. If neither party tenders performance, the closing date is automatically extended indefinitely until one of them does so. C. Buyer finds seller's title unmarketable. If a buyer determines that the seller's title is unmarketable, the buyer must give the seller reasonable time to cure title defects. 6. Remedies for the breach of the sale contract. Damages. The usual measure of damages is the difference between the contract price and the market value of the land on the date of the breach. Incidental damages such as title examination and moving or storage costs can also be recovered. Liquidated damages. Sales contracts usually require the buyer to deposit earnest money with the seller and provide that if the buyer defaults in performance, the seller may retain this money as liquidated damages. The courts routinely uphold the seller's retention of the deposit if the amount appears to be reasonable in light of the seller's anticipated and actual damages. Many courts will uphold a retention of the deposit of up to 10% of the sales price without further inquiry into its reasonableness, even without a liquidated damages clause. Courts may uphold retention of the deposit on the ground that giving restitution of the funds to the buyer would unjustly reward a party in breach. Letter B is specific performance. For the buyer's remedy, 1. A court of equity will order a seller to convey the title if the buyer tenders the purchase price. The remedy at law, damages, is deemed inadequate because the buyer is getting land and land is unique. If the seller cannot give marketable title but the buyer wishes to proceed with the transaction, she can usually get specific performance with an abatement of the purchase price in the amount reflecting the title defects. The seller's remedy, somewhat illogically, the courts also generally will give a specific performance decree for the seller if the buyer is in breach. This is sometimes explained as necessary to have mutuality of remedy. A few courts in recent years have refused to award specific performance to sellers if the property is not unique. For example, if a developer is selling a house in a large subdivision of similar houses. C. Special rules for unmarketable title. If the seller's title is unmarketable for reasons that do not include the seller's bad faith, for example, he did not realize that his title was defective when he signed the contract, about half of the courts limit the buyer's recovery of damages to incidental out-of-pocket costs, for example, title examination, etc., and return the buyer's earnest money deposit. The other half of the courts give the buyer the standard measure of contract damages mentioned above. Which sounds like it should be a specific performance. But I guess you wouldn't because it's a bad title. So never mind. Seller's liability for defects on the property. Warranty of fitness or quality. New construction only. The common law rule is that contracts of sale and deeds of real property, unlike conveyances of personal property, carry no implied warranties of quality or fitness for the purpose intended. One exception is a contract for the sale of a residential building under construction or to be constructed on the ground that the buyer has no opportunity to inspect. Most courts extend the implied warranty of fitness or quality to the sale of any new house by the builder. The warranty implied is that the new house is designed and constructed in a reasonably workmanlike manner and suitable for human habitation. Courts are split, however, on whether a subsequent purchaser can recover from the original builder because of a lack of privity. And you see that being tried in Spate v. Walters and Conway v. Cutler Group, which is PA, 2014. The earlier being Iowa, 2008. B. Negligence of the builder. A person who contracts for construction may always sue a builder for negligence in performing a building contract. Moreover, many courts now permit the ultimate vendee, for example, a subdivision buyer, to sue the builder despite the fact that the seller hired the builder and the buyer thus lacks privity. C. Liability for sale of existing land and buildings. The seller of existing land and buildings, not new construction, may be liable to the purchaser for defects in the improvements, for example, a leaky roof or basement, termite infestation, or non-functioning septic system, on any of several different theories, which are misrepresentation, including fraud, active concealment, failure to disclose, disclaimers of liability, as-is clauses and specific disclaimers can mitigate that. So, for misrepresentation, this theory requires proof that the seller made false statement of fact, oral or written, to the buyer, and the buyer relied on the statement, and that it materially affected the value of the property. The seller must have known that the statement was false, or have made it negligently without taking reasonable care to determine the truth. 2. Active concealment. The seller is liable as above, even without making any statement, if the seller took steps to conceal the defects in the property, for example, paneling over a wall to conceal cracks. 3rd, failure to disclose. A majority of states now hold sellers liable for failure to disclose defects if the following factors are present. Roman 1, 2, and 3. 1. The seller knows or has reason to know of the defect. Ruminant 2, the defect is not obvious or apparent. The seller realizes that the buyer is unlikely to discover it by ordinary inspection. And ruminant 3, the defect is serious and would probably cause the buyer to reconsider the purchase if it were known. These decisions are more likely to impose liability on the seller if the property is a personal residence, if the defect is dangerous, and if the seller personally created the defect or previously attempted to repair it and failed to do so. Disclaimers of liability. Sellers sometimes attempt to avoid liability for property defects by inserting clauses in the sales contracts exculpating the seller. As is clauses. A general clause such as the property sold as is or with all defects is not sufficient to overcome a seller's liability for fraud, concealment, or, in the states that recognize it, failure to disclose. 2 specific disclaimers. If the exculpatory clause identifies and disclaims liability for specific types of defects, for example, seller is not liable for leaks in the roof, it is likely to be upheld. 8. Real estate brokers, and 9. Title insurance. 8. Most real estate sales contracts are negotiated by real estate brokers. The broker who obtains the listing from the seller is the seller's agent. Other agents who participate in the sale through multiple listing service are also the seller's agents unless they specifically agree to serve as the buyer's agent. While these agents owe a fiduciary duty to the seller, they also have a duty to the buyer to disclose material information about the property if they have actual knowledge of it. Traditionally, the agent's commission was earned when she found a buyer who was ready, willing, and able to purchase the property, even if the buyer later backed out of the contract. But the growing trend of the cases is to award the commission only if the sale actually closes or if it fails to close because of the seller's fault. Title insurance. A title insurance policy ensures that a good record title of the property exists as of the policy's date and agrees to defend the record title if litigated. The insurance can be taken out by either the owner of the property or the mortgage lender. An owner's policy protects only the person who owns the policy, for example, the property owner or the mortgage lender, and does not run with the land to subsequent purchasers. In contrast, a lender's policy follows any assignment of the mortgage lender. I will pick up with deeds at a later recording.